As artists, we often focus on creativity, vision, and technique. But if you're selling and sharing your work, you're also stepping into the world of law. I worked as a lawyer before devoting my life to painting. And today I want to share 10 pieces of legal advices that I think every artist should know and acknowledge. They might help you to protect yourself and keep you on track with your art, your money, and your peace of mind. I'm a lawyer first and then an artist. I see most things through the lens of a lawyer at the end, but they can also hinder me in my communication. It can also make me a bit scary to work with for galleries and clients because I can be pretty forceful with asking some pretty, I would call them uncomfortable questions when it comes to the contracts and what we are about to engage in. But for me, my peace of mind is worth a lot. My sleep is worth a lot. I don't want to worry about things that I maybe could have foreseen. So here is 10 advice that I recommend you as an artist carry with you in your journey as a painter. My name is HP. All right, so one, contracts does matter. If you sell through galleries, work on commission or collaborate, always get an agreement in writing. Even a simple contract will prevent misunderstandings. But let's be honest about this one, because sometimes as artists, we feel we can't demand contracts. You're excited about the opportunity, the project, you want the sale, and now you want to have a written contract with the gallery or the client asking for a bunch of paperwork. My advice is start small. Even a email confirming terms, price, commissions, rate, delivery date is better than nothing. Now we'll get back to this, but oral agreements are also binding. But in law, we consider them very hard to prove. Who said what? And the one claiming what has been said to benefit of what was said is the one that has on their map to prove it. So contracts does matter. Second one is copyright is automatic. The moment you create a painting, depending on if it reaches the threshold of originality, it's protected by copyright law. You don't need to register that, but you should keep a proof of creation, like dates, photos, and such. I have a different video on documentation, and this is one part of why that's important. Licensing versus selling. Selling a painting doesn't mean you give up the rights. You can keep the copyrights and you can keep the immaterial aspects if you don't sign them over via contract. That means you can still create prints. You can still post it as your work, unless if you gave those rights up within the purchase agreement. There is one right that you can't transfer, and that is the ideal right. That is the right to have your work respected by the buyer. That means that they can't paint, say, a penis on your painting and sort of claim that was yours. That's a copyright that is within a different scope, but that one, you always keep the respect right or the ideal right. Well, protect your name and brand. You're building a career. Consider trademarking your artist name or studio brand. It prevents it from being used commercially by other means. And it can actually help you within litigation. It makes it easier to litigate a trademarked brand instead of a copyright material, because there's always a chance of something being created within the copyright scope in double creation mode. That means two works of art was created identically during the exact same time span. And now with AI, it's very possible. So be clear about commissions. For commission work, outline the scope, deadlines, revisions, and payment terms. Many conflicts come up from unclear expectations, and that is something you can foresee with having a good standard contract within your email agreement. And also be wary about clients and galleries that does not really clearly answer the definitive answer, because then the contract is sort of hung. It's hard to see what you actually agreed about. So be vigilant about answers that is not yes or no, that answers that are dependent on a certain circumstance that you don't know if it will fall through. This one is very important. This is what makes me sleep well at night, because sometimes you enter into a contract with somebody that you might not know if they financially suitable to go into a deal with. You don't know if they have debts. You don't know if they are in bankruptcy mode. You have to know who you are contracting with. This one is overlooked all the time. Know exactly who the counterpart is in your contract. Is it a gallery? Is it a company? Is it a private individual? Is your commission with the client directly or through an agent? Always get the legal name and the social security number or the number attached to that person. And I take it as far as I take a credit score. If someone were to sell my paintings and take home my sales before providing me with my cut, I want to know that they're not in debt, because I will be shit out of luck to get a hold of that money if someone swoops in and empties the bank account. This connects to the contract. How beautiful worded a contract might be. It means nothing if the other side can't provide payment. So that's a major one. There is also, in law, there's often this misconception about oral agreements are not binding. Oral agreements are very binding, but they're extremely hard to prove. In most placements, so while a verbal promise may technically count as a contract, without documentation, it's your word against theirs. Always follow up with a short confirmation, even a quick email, to protect yourself. When I enter into oral contracts, I'm not shy to take up the camera and just film them saying what the contract is and then me saying yes. It's a bit cringe, but I am old and cringe. So always read the contracts carefully. Commission percentages, who covers shipping, who insures the work. Don't assume it. Have it clarified. It is often now you, as an artist, you have to pay up front to be in a gallery at a certain location. Also make sure that you have the financial stability to enter these contracts, because if you don't fall through a contract like this, you might be held accountable for the part that they assumed that they would make from you fully developing that contract. And if there's no contract at all, send an email that sums up what you think the terms are, and then they can accept it or they can deny it. So many artists now have a homepage or like a type of sales platform. Now, there's online sales terms you have to attach to the purchase button that you have to click to go through and purchase the item. But few actually read their own sales and terms agreement, and they can vary a lot. My sales and terms agreement is very, very clear. There is no denying. Make sure terms are clear. Shipping, returns, digital rights, a short, plain language policy that saves a lot of trouble later. Also, be sure that you might be dealing with private clients, and there are different rules and different laws. You can't write any contracts with private clients. With clients, as in companies, you can be pretty loose and fast with the contracts, but within consumer law, you're bound to a certain type of law. Now, the most important one, I would say, is this one. The 10th one. Avoid arbitration clauses. This one is tricky, but super important. Watch out for these clauses in your contracts. An arbitration clause means that if there were to were a conflict, you can't take it to normal court. It has to go to a private arbitration system. That might sound fine, but the arbitration system is often very expensive and you have to pay off upfront, and it might limit your rights for appeal. For an independent artist, it can be impossible to afford. If you see an arbitration clause, is this worth it? If it's possible, ask to remove it, and if not, at least understand what you're agreeing to. And a lot of larger galleries and larger purchaser of art, they have the arbitration clauses to circumvent the possibility of going to court, maybe if they don't pay the right amount of money. Be very, very wary of this one. So to sum it up, contracts matter, copyright is automatic, selling isn't licensing, protect your name, clarify commissions, know your contract partner, oral agreements are binding, read gallery agreements, set the online terms perfectly, avoid arbitration clauses. It can feel intimidating to read the fine prints when all you want is to do and sell art. But protecting yourself legally is also protecting your creativity and your mind and your collectors. Well, that might have been boring, but if you found this useful, like and subscribe. It helps me to share more insights of the intersection of law and art. Thank you a lot for watching. See you again next time.